of justice, what are the challenges associated with it? Of late we are observing many tribunals coming up. So there might be a question on tribunalization of courts or tribunalization of justice in India. Tribunalization of justice, what are the challenges associated with it? Do you support or tribunalization of justice? Of late we are observing in the recent past. Do you support, and what are the challenges associated with it? Tribunals are meant for expeditious adjudication. Tribunals are meant for expeditious adjudication, speedy justice. Expeditious adjudication means speedy justice. In the Constitution we have two articles, Article 323A and Article 323B. In the Constitution we have two articles, Article 323A and Article 323B. In that, Article 323A deals with Central Administrative Tribunal and State Administrative Tribunal. Article 323A deals with Central Administrative Tribunal and State Administrative Tribunals. According to Article 323B, any new tribunal can be established by Parliament by law. According to Article 323B, any new tribunal can be established by Parliament by law. That means Parliament by law, by enacting a law, can establish a new tribunal. Parliament by enacting a law can establish a new tribunal. Tribunals have many advantages. Number one, they deal only with the particular cases for which they were created. They deal only with the particular cases for which they were created. Number two, speedy justice. Number three, cost effective. Cost effective. There won't be any delay and adjournments, excessive lawyer fees. They are cost effective, means very cheap. And tribunals always need not follow strict legal procedures. Tribunals always need not follow strict legal procedures. They can even follow principles of natural justice. They can even follow principles of natural justice. Unlike ordinary courts, where only legal experts, lawyers, judges present, in tribunals subject experts also present. Tribunals are quasi-judicial bodies. They are not completely judicial bodies. They act like judicial bodies. They function like judicial bodies. They are not completely judicial bodies. They are quasi, Q-U-A-S-I. They are quasi-judicial bodies. And tribunals have expert members, so they will have domain knowledge. So these are the advantages of having a tribunal. But of late we are observing, for each and every subject a tribunal is being constituted. We have motor vehicle accidents tribunal, income tax appellate tribunal, national green tribunal, death recovery tribunal, intellectual property tribunals. Name any field, you are having tribunal now. So excessive tribunals also pose challenge to in many respects. Number one, in the tribunals also justice is being delayed. Tribunals are functioning as good as normal courts. In tribunals also justice is being delayed and tribunals are functioning as good as normal courts. Number two, tribunals are functioning like asylums or stopgap arrangement for the officers who want deputation. So, they work like asylum or stopgap arrangements. Number 3, legal formalities and procedures also entered into tribunals. Legal formalities and procedures also entered into tribunals. And appeals from the tribunals all the time, creating a further layer in the process. You are making extra burden on the judicial system. That means in between you are inserting a mechanism. Again from tribunal you can go to High Court, then to Supreme Court. From most of the tribunals you can go to High Court and then to Supreme Court. Means excessive process and the cost incurred in creating and running a tribunal. The cost incurred in creating and running a tribunal. The cost incurred in creating and running a tribunal is actually, if you analyze the cost benefit analysis, the cost is more and the benefit is less. The cost is more and benefit is less, but the solution is not completely closing up the tribunals. Establishing tribunals wherever needed, ensuring that tribunals will have time boundness in justice delivery process. Establishing the tribunals wherever needed, ensuring that tribunals will deliver the justice in time bound manner. At the same time, also making the normal courts, regular courts, to deliver the justice in a speedy manner. All these things if you put together in a balanced way, we can establish and continue few tribunals, if not establishing regular tribunals for each and everything. At the same time, minimizing the legal and procedural bottlenecks in speedy justice. This should be the need of the hour. This is the answer for the question.